All right, thank you for joining us today. Can everybody hear me? If you just want to chat in the chat box, type something there just so we know that everybody can hear us. Make sure everybody's technically working. And we're going to be doing a webinar today on what every estate plan should include. And our guest today is Moira Laidlaw. Moira is the managing partner at Hollis, Laidlaw & Simon. Her practice encompasses a broad range of trust and estate planning services, including wills, trusts, guardianship, probate, estate administration. And her depth of experience also includes elder law, special needs planning, Medicaid, long-term care asset protection, small business planning, and high net worth estate tax planning. Also, she's certified as an elder law attorney, which is only one of about 400 attorneys in the U.S. who hold this designation. And she's accredited by the National Elder Law Foundation as well as the American Bar Association. I've known Moira many years now. She's done estate work for my clients, my family, my team. Can't recommend her enough, and she's an absolute pro and expert on these topics. And I think it's so important these days to make sure that you have your estate planning set up properly, especially in these times, because we don't know what the future holds, and it can make it easier on you and your family if you do things correctly, as well as financially better as well. So without any further ado, I'll hand it over to Moira to talk to us about estate planning and what every estate plan should include.
Thank you, Mark. I really appreciate it. I'm going to take a moment and I'm going to stop sharing your screen and start to share mine.
Fair enough.
And I just want to really thank everyone for joining us today. And I think we're in a little bit of a strange time period in terms of how time even passes right now. And I feel on any given day that I blink and, the entire day has gone by in a myriad of different ways. So I really appreciate people choosing to spend their time with us today. So I'm going to take you through this slideshow. Hopefully it's going to kick in. Here we go. So, a major theme of estate planning that I often talk about in lectures like this is truly that the planners win. So I'm going to be weaving a few anecdotes throughout about why, when a person has planned in this scenario, it works so well, and what happens when a person hasn't planned, to show you how brutal some of the rules can be in terms of navigating it in a situation in a more reactive way at a time when a family is often most vulnerable because of an underlying health event. And estate planning is not just about death. I think more importantly, often it's really about protecting someone while they're still alive. I'm going to just share my bio slide for one moment. Mark did a really good job covering it, but if you look at some of my committee work and volunteer work and designations and admissions, but especially the committee work, it's clear that I live and breathe estate planning and guardianship and trust and estates issues. And whenever you're choosing a professional to work with in this area, make sure that they too are living and breathing these issues. For better or worse, we just live in a modern world where you really do need to work with someone who's living and breathing these issues in order to be kind of navigated through it most expeditiously. And then, of course, because I am a lawyer, I'm going to start with a legal disclaimer that this is not to be meant to be considered specific legal advice to your situation. Our firm actually offers complimentary consults. We spend an hour with people. So if you have specific questions unique to your family, please feel free to contact our office. Other lawyers' office also very similarly offer complimentary consults. So try to find a lawyer that will do that. For today's session, as Mark mentioned, we will be answering questions. We're going to leave time for that. So if you have questions of a general nature, please do post them to the chat, send them either to Mark specifically or to the whole group. Just make sure that, again, they're not specific and don't reveal any confidential information. All right, so in general, we're going to talk first about some key estate planning documents. Then I'm going to review a standard timeline for what issues you want to be thinking at different junctures in life. And then we're going to talk about how it intersects with real estate. As Mark mentioned, we have known each other for many years, and we've encountered a lot of these situations in some of our transactions together. In preparation for the call, it was like a walk down memory lane to certain of the trickier real estate, thornier issues that we've encountered together. So I'll talk about some of those once I give a basic overview. All right, so this is my toolkit, essentially. These are the key documents when a person contacts us to do estate planning. These are the key documents that we're looking to help them put in place. And the most common scenario is someone calls my office, says, I need to do a will. I was recommended to Moira from a friend, and I'd like to meet with Moira about doing a will. So I'm always happy to meet with them and talk about doing a will. But it's everything before the will that I also want to help this person with. Because as you can tell from this chart, a will is only effective upon death. So if I have a client who's alive and in the hospital, and healthcare decisions need to be made, and the mortgage needs to be paid, and taxes need to be filed, and healthcare billing needs to be navigated, none of that authority is going to come from a will. It's all going to come from all these other documents on the left-hand side of the page as I look at the screen. The most important document is the one that I list first. It's the durable power of attorney. That's the power of attorney document that's going to cover everything that's not a healthcare decision. And it's going to be valid the moment that my client signs it, and it's going to continue to be valid if my client loses capacity. And that's why it's called durable. It endures when my client loses capacity. It's a very confusing word. I get asked what durable means all the time. Very rarely in my practice do we use non-durable powers of attorney. But real estate is sometimes one of those examples. Like, let's say I am going to be buying a house, Mark is my broker, we've set a closing date, but I can't make the closing date. I might give my real estate attorney a non-durable POA specific to the real estate transaction that I'm going to be out of town for. But you would never really want to do your estate plan with a non-durable power of attorney, because you see, there would then be this big empty white space of authority in the moment in time when you've lost capacity and most need help. So every really effective estate plan has a durable power of attorney, not a non-durable one. Similarly, springing powers of attorney, my clients often want to do. They don't want to give authority ahead of time. The problem with springing powers of attorney is it can be very hard to prove to the person you need to accept it that it has properly sprung. So the idea of a springing power of attorney is that I'm going to give this person a ton of authority, but only once I no longer have any authority. And banks don't like working with springing powers of attorney. They don't want the liability that they've, honored someone's authority at a juncture in time when it wasn't ready to be honored. So springing powers of attorney can actually be pretty difficult. And then the last set of documents that we're using to really help a person as sort of a basic estate plan are the healthcare directives. They are called different things in different states. I'm licensed in New York, New Jersey, and Connecticut. In New York, we have healthcare proxies, living wills, and then we also use HIPAA designations, and we do that in 3 different documents. In Connecticut and New Jersey, there are these kind of more unified healthcare advanced directive templates that are followed instead. And so it just varies a little bit from state to state how many of these healthcare documents that you might want. But again, these are for the healthcare decisions. So a basic estate plan will always come with a power of attorney, healthcare directives, and a will. with the will being what happens with your assets upon death and who's going to be managing your estate, which then becomes very relevant for any later real estate transactions that flow from an estate administration. What is optional is the very last layering of documents at the bottom of this chart. Those are living trusts, and very confusingly, trusts can be created inside wills as well. But when you create a trust while you're still alive and it comes into being, that's often referred to as a living trust or an inter vivos trust. So all it means is it's a type of trust that's created while you're alive and not inside your will and later upon death. And those types of trusts can be what are known as revocable or irrevocable. So that's what I'm generally reviewing with clients in the complimentary consult, and frankly why I do complimentary consults, because I need to talk to someone in order to know what I need to be able to recommend, and then based upon what I recommend is how we then give the cost estimate. So I really have to kind of spend some time with the client to know what of these documents they need and who are the best people for them. Okay. So here's our estate planning timeline. At the age of 18, our parents naturally lose authority over us and no longer have the ability to make healthcare decisions for us or transact any of some of the basic financial issues for us or healthcare billing issues for us. So the first touch point with my office is sometimes at the age of 18, especially as children in our area. I live in Westchester County and our primary office is located in Mount Kisco. And our most common touch point is a client of ours or a family friend has a child going off to college, and they want to make sure if they're at UVM, say that, and the parents get a call, one of those dreaded calls in the middle of the night that their child's, gone from the university to the local hospital, that they have the authority they need to talk with the doctors in that situation. And so that's just a really good set of advanced directives we're going to do for that 18-year-old. They don't typically have anything, if anything, starting college, they might, be starting life off with a little bit of debt. And so if we even do a will at all, we're doing just a really simple basic will. And that is kind of where people can stay for a period of times, sometimes upwards of 30, you're making your way through life. You're not really thinking about estate planning. You haven't had any major events like a marriage or the birth of a child. But then we get to that next marker of what I call the basics plus. And there's where people have started to marry, started to create families, has some issues surrounding guardianship for minor children, and not just who's going to be taking care of the children, but who's going to be taking care of the children's money. And you can separate who takes care of the kids versus who takes care of the kids' money, because that's sometimes a different skill set. It can be the same people, but doesn't have to be. We're also having some tax planning discussions at that point, especially with people who are closer to 55. Because by then you maybe have 30 years of a career under your belt, you've amassed a 401k, you've developed more equity in your real property, and we're starting to do a little bit of tax planning to the extent it's warranted to save on estate taxes. From 55 to 65, that's where some real interesting issues can start to develop for us. So there might be marriages that parents are a little bit nervous about, and they're starting to think about inheritance for children and whether there should be some protections in case the children get divorced. They're also maybe thinking about how responsible the children are now and that it's time to graduate the children into some of these fiduciary roles like executor or a healthcare proxy or a power of attorney as a backup. Very common in that 30 to 40 to 50 range, you're maybe naming siblings as a backup or a trusted family friend. And then the older your children get and they graduate out of guardianship and they graduate out of needing certain protections for their money, they can potentially then graduate into helping you as a backup. Then when it comes to maybe people who are close to retirement or fully retired, there can be some health issues that develop, maybe some touch points with administering your own parents' estates that make you realize you want to make things easier for your own children or families and loved ones. And so you start to think about how to avoid probate upon death. You start to also think about, how do I protect assets from long-term care costs? And that's where we do a lot of real estate work. Real estate often has the most equity built into it that we want to make sure doesn't get lost to placement in a nursing home or needing home care provided by New York State Medicaid, or in Connecticut it's called Title 19. And then I would say, and you'll notice I have 110 years old as my upper age band. Life is getting longer and longer. And so in that 80 to 110 band, I've had clients live to 110. So we're sometimes really navigating actual nursing home or home care applications for clients in this band. And we're doing a lot of trust and estate administration guidance with winding down affairs. And, that's why I have come to know Mark and his team so well, is they have helped a lot of my clients through this particular chapter. All right, so I thought I would start with a frequently asked, just general question, because that might, as questions start coming into the chat, I thought that might really help us with kind of answering some of the most common questions. And then Mark, if you could help keep an eye on the chat and let me know of anything that I don't cover.
Yeah, absolutely. And yeah, just at the bottom of your Zoom screen, there's a little chat button. Just click on there, post your questions, and we'll get those answered. Okay. So a really commonly asked question is, how often should I be looking at my estate plan? I have a general rule of every 3 to 5 years. It's 2020. I was meeting with someone this morning to put an estate plan in place. She's 30. I said, just calendar for 2025. Just know it's 2020. Every 5 years from now, you're just gonna just do a little touch-in phone call with me. But then there can be certain key markers when you want to be sure to make sure that your estate plan is up to date. If you get married, if you have a child, and then of course, what I call the 3Ds. So whether there's a death in the family or a divorce or some sort of person in your life, whether it's yourself or a spouse or a child who presents with any kind of disabling condition, that would be another time to review your estate plan. All right, I'm also asked a lot about how do we avoid conflict. A tricky thing about wills is they can never be declared valid while you are alive. And that's a benefit to trust planning, because trusts come into creation when you are alive, and there's no question as to their validity. There can be objections later on to a trust, but it's not a question of whether the trust is valid as long as you worked with and received appropriate legal counsel. And it's harder to undo something, whereas a will is just a piece of paper until a probate court judge declares it to be valid. And a probate court judge will never do that until they are shown a death certificate. And it's just a tricky situation. So what I find prevents the most conflict in my estate proceedings is people planning early. As we age, our biggest risk, or I should say, the biggest risk factor for cognitive decline is age. I'm on the board of the Alzheimer's Association. I just heard a lecture on this last night at our local chapter meeting. So 1 in 3 people above 85 have some sort of cognitive-based presentation and decline. So age is our biggest risk factor, so plan early, because the more your faculties are intact, the stronger likelihood that your estate plan is going to be valid. And be consistent over time to the extent possible. If circumstances change, then that's different. But
having a consistent estate plan so that if one will gets overturned, you go back to the prior will, and that prior will largely says the same thing, then they have to get multiple wills declared invalid in order to really defeat your estate plan. Okay, and that kind of leads, I think, into some of our house issues, Mark, and some of the ones that we were talking about in preparation for today.
Yeah.
I'd say the most important thing with having a smooth house sale in any kind of estate proceeding is having a really good fiduciary, and preferably one.
Right.
At most
Right.
two, but again,
Yeah.
preferably one. So that means if you have 3 children and you feel bad about choosing among your 3 children, you have to really think about how hard it is going to be and how expensive it's going to be for the estate lawyer to be working with 3 different clients and answering 3 different sets of questions, and a broker like Mark taking direction and having to, give information to 3 different people. It just slows things down. It makes it more expensive.
Yeah. One of the things that I see, and I'm sure you've seen too, more, is that when you have multiple people involved in the decision making in this, I've seen families that just completely get ripped apart because of the decisions that need to be made. One family member, one child, wants to do it this way, other child have other financial needs or whatever it may be. And by the time the thing is done, they almost hate everybody hates each other. And that's certainly not what the parent was intending, by doing that. So how do we get around that? What advice do you have there with that?
I think that the parents know a lot about the dynamic between and among their children, and they also know, while they're alive, some of the emotional touch points surrounding some of the real property, especially real property that's been in the family for a long time. Mm-hmm. That isn't even always the case with a primary home, but sometimes a secondary lake house or cabin of some kind where everyone vacationed, but now the kids are throughout the country and only one child's local and could use it, but wants everyone to still hold on to it. So to make things flow smoother in that instance, when I'm working with the parents on developing the plan, we're talking about those issues and we're thinking them through ahead of time. And I'm having the parents talk with the children ahead of time. And then we're documenting what's been agreed upon or what the parent has ultimately decided, despite that there isn't agreement, so that we can require certain things to be done rather than leave it up to fiduciary discretion or agreement among the children. So it's really about opening up to your estate planning lawyer and working with a lawyer who's going to allow enough time in the engagement for these issues to develop and be raised and addressed.
Right.
Yeah.
And so, another question that we touched upon it earlier that I'd like to speak to is the chain of title, right? So we do a lot of estate work, and we run into these situations. For example, the grandparents own the home, but their child had lived there. That child got married. They were still in the house. Mom and dad or grandparent or parents really passed away. And then, going down the road, the husband passes away, and now his wife, owns the house, and there's this estate. But there was never any update to the chain of title for the last 3 generations, right? And then they go to sell it, and what happens?
A lot of delay.
Yeah.
And then during all of that delay, while you're probating or administering multiple estates to be able to clear the title, and I'll walk you through that in the illustration that you gave, but during all of that delay, if that's a property in Westchester County that has $30,000 a year of real property taxes on it, that can be such a burden if all the estate owns is essentially real property that costs the estate money, while it's also costing that fiduciary to hire a lawyer to bring all those multiple estate proceedings. Right. So in that example that you gave where the grandparents own it and then the son is their child, and those grandparents die, and the son is married there. Well, you have to pray that that son was an only child.
Right.
Because if not, that son's estate is only receiving very likely whatever equal percentage all the other siblings are receiving, unless the grandparents had a will that specifically bequeathed the house to that particular son. Mm-hmm. And that can be a heartbreaking thing for that surviving spouse of the son to find out, that I thought I've lived here my whole married life and we never did any estate for the grandparents. You start to just feel like you own it. You've been paying the taxes all these years as a married couple with your marital income. And then all of a sudden you find out that you are going to inherit what your husband had, but your husband really only had a 1/3 interest because he had 2 siblings and the will left everything to all the kids. Mm-hmm. So not addressing that sooner is a problem, because what happens then in some of my estate cases and our estate cases that we've seen in this way, when you go to it, sometimes it's not just in that instance the wife's husband who has passed away at that point. Sometimes one or more of the siblings have also passed away and their estates were never administered. So you might be doing an estate administration for grandma, estate administration for grandpa, estate administration for like the son, estate administration for another child, and dealing with nieces and nephews in law. It is a quagmire.
Yeah, and we've seen that. Yeah, absolutely. So I have a question from Dottie here. She asks, what kinds of assets can be put into an irrevocable trust, and how easy or difficult is it to move assets out if needed?
I'm going to answer this based on New York law, because the answer is going to change by state. So, if there's another state intersection, please just contact the office and we can always have a consult. But under New York law, we have wonderful trust rules. And we also have a very good state Medicaid program. I would say one of the best in the country. It's in the process of becoming a little worse, but even at being a little worse, it's still one of the best, because we actually offer home care through our state Medicaid program. The purpose of irrevocable trusts and transferring homes to them is to position yourself to, without penalty, access New York's Medicaid program. And Medicare will not cover much, if any, of a nursing home stay, and provides very little home care. So it's that type of long-term care that irrevocable trust is going to provide. It's relatively easy to create and transfer a home to. You do want to use legal counsel, because there can be inadvertent tax implications if you do it the wrong way. So when we work with clients, I like to say we use the best of the tax code and our knowledge of New York's Medicaid rules in order to have the proper trust provisions for the best outcome for families.
Okay. And also, what assets are actually protected with a revocable trust and an irrevocable trust?
Revocable trusts afford no asset protection. Because they are revocable, your creditors can make you revoke it, and they can attach assets inside the trust. The purpose of revocable trust planning is really to avoid probate. So if your sole goal is to avoid probate, and that is a sole goal in certain states like California and Florida and Connecticut, which have more complicated probate compliance rules associated with them, more costs and more delay, that is often a go-to estate planning technique, using revocable trusts for persons of any age.
Gotcha.
In New York, our probate court is not something to live in fear of. It's relatively simple, especially for married couples. I'm not thinking revocable trusts, especially because married couples so often naturally avoid probate. But I am often thinking irrevocable trusts, because every Medicaid program has to apply a 5-year look back to qualify for nursing home care services. So you want to get a trust created, you want to get it funded 5 years in advance, preferably, of when you may need nursing home services. Now, the way that New York is a great jurisdiction is, let's say in 2020, I create an irrevocable trust and I transfer my house to it. But then in 2022, God forbid, I have a stroke, I need rehab, and I need a sustained level of care from there in a skilled nursing facility. Under New York law, I can revoke that irrevocable trust that I didn't make the 5-year look back, as long as the other trust beneficiaries agree with me. So that would be my children in that instance and my spouse. And as long as they agreed, New York law lets all the trust beneficiaries come together and revoke, even an irrevocable trust. So New York's a really friendly jurisdiction for irrevocable trust planning with protecting assets in mind.
All right. And one last question before we wrap up. Can you give us a sense of what's happening with the new Medicaid laws, or I guess it was a community Medicaid was the question, just those changes?
Yeah, so I used to be able to tell clients such good news with community Medicaid, and I can only tell them that that might still be the case until October 1st. So while all of us were navigating the pandemic issues and trying to secure masks and paper towels and disinfect our houses, our New York budget was passed, and what they snuck in was what is now a 2.5-year look back for home care. There used to be no look back for home care. A client could walk into my office, say that they had a spouse that needed home care, and we could look at the assets that the couple owned and make the family eligible for home care, depending on what they owned and how they owned it, anywhere from maybe, I would say, 2 weeks to 2 months. So now is actually a really important time to be getting more information about whether doing Medicaid planning is appropriate, because now might be a window of time that you can still do those transfers, because the budget is ambiguous, but they talk about an effective date of October 1st. We still need more guidance, but I know that if you transfer it after October 1st, you're not going to be grandfathered. There's possibly an opportunity for grandfathering between now and October 1st.
Okay. All right. Thank you. So we're wrapping up, but if you have any questions, certainly you can email me at mark@markboyland.com, or you can email Moira at nlaidlaw@hollislaidlaw.com. I can go back up to the first slide and you can see my email address there. Yeah, and obviously there's a ton of issues in different directions that estate planning can go into. Obviously we can't cover them all today, but I want to thank Moira for coming on today and kind of giving us the 30,000-foot view of what you should consider when you're doing it. Is there anything else you wanted to mention before we wrap up, Moira?
No, I think we did cover the main topics. And just the reason why planners win is because it's a lot more complicated with court involvement without the documents I referenced. So I would just have that as the main takeaway.
Okay. All right, great. Well, thank you again. Once again, if you have any questions, you can reach out to us. Real estate, I'm happy to answer any questions you have about that, and any estate law, elder law planning, please reach out to Moira. Thank you so much for joining us, everyone. Take care.
Thanks for having me, Mark. Great team you've got there.
Oh, thank you. My pleasure.
Bye now.